affirm that the statistics element of all this is a really important aspect, and the efforts of Reputation VIP from the very beginning in releasing quite well systematized statistics have added pressure to the commercial entities. A number of people here were involved in an academic letter on the anniversary of the ruling, asking a number of questions of Google particularly to release statistics, and I've been informed that they're going to issue some sort of response at the end of this month. And the independent set of statistics that we have on 8% of those cases is a really useful counter, as well as the statistics that I think have been generated from the DPA, so definitely watch this space. Let's see.
Thank you very much. Shall I use the microphone as well? Thank you very much. Hi, thanks very much for the invitation to come here. Yeah. So I'm Steve Wood. I'm the head of the policy department at the Information Commission's Office. For those of you who haven't heard of us before, we're the UK's independent regulator of the Data Protection Act and also the Freedom of Information Act and other associated pieces of legislation. So that means that members of the public can complain to us free of charge as part of our functions if they believe their personal data has been processed in contravention of the Data Protection Act, or under the Freedom of Information Act if they believe a public body is not providing them information that they have requested from them. The ICO, obviously within the framework of the European Union, is a European Data Protection Authority. So we work as part of the Article 29 working party that I'm sure a number of you are aware in this area. It's obviously been an important role in terms of the guidelines and the criteria we've issued. We've worked at European level. We've tried to work pretty quickly to try to get some clarity out there in terms of what the broad overall guidelines we were going to use collectively across Europe in approaching the application of the Google Spain judgment. One thing about the ICO I think we found useful in our experience, I won't say navigating the quagmire, because I don't think we've sunk yet. I think we've managed to step through the quagmire, but it is difficult and challenging. And I think one benefit we've had at the ICO is because we're an access to information and a data protection regulator, we have had experience of freedom of information issues before, and we certainly believe that's helped us. Certainly the most difficult cases on access to information I've dealt with at the ICO in their 8 years was MPs' expenses, and that actually generated some really difficult issues about what's the boundary between an MP's public life and an MP's private life, how much detail can you go into about where an MP regularly uses a restaurant, how much information should be revealed about their home postcode, etc. So we have had some experience of sort of balancing and thinking about those rights. And obviously we're a data protection regulator, we strongly believe in upholding data protection rights, but we do understand and get the importance of freedom of expression in balancing those two different areas. So I want to talk about my 10 minutes. This is a complex and controversial area, but we would say it is delivering privacy benefits for individuals. As Ashley said, it is difficult, things could be better, there's things to be worked out in future legislation, etc. So there are positives and there are challenges as well, and I'll try and cover both. So in terms of the ICO's reaction to the Google Spain judgment and the reaction of the data protection authorities across Europe, we welcomed the Google Spain judgment when it came out. So it clarified that search engines such as Google were processing personal data, they were data controllers. It clarified the issue of establishment as to whether Google Spain were essentially processing in a way where it was linked to the processing of Google Inc. So there was that establishment of the Google search engine in Europe. That question was addressed. So it actually brought forward really answers to difficult questions, which as data protection authorities we felt were important really about how the application of data protection law needs to actually catch up with the way search engines have developed. Yes, the judgment wasn't perfect, and certainly that day, as Ashley was describing, when we were all rushing to sort of analyse the judgment and think about what was in it, or what a lot of people were arguing about what wasn't in it, in terms of how to explain perhaps the relationship between search engines and freedom of expression. But overall, we felt the judgment could be welcomed. The next thing to talk about is the term right to be forgotten. Is that a helpful term in itself? I think we'd say possibly not. We've generally at the ICO weren't talking about a right to be forgotten before the judgment came out. There's a right to erasure and a right to object in the current Data Protection Directive. And Article 29 has generally talked about the term of delisting as the European term in terms of the rights of individuals to request the removal of search results when a search is made against their name. And we feel this is perhaps a better way of explaining the concept in this area. So the effect of the judgment is a helpful and proportionate tool to help citizens control their personal information. It's a way really of actually making information less available. It steps down the availability of information. We understand that it perhaps can set the expectations of individuals quite high to talk about information being deleted or the internet forgetting is a very, very difficult concept. And as a data protection regulator, we want citizens to have rights that they can actually exercise and use in practice. But it's certainly important that individuals do have that right to be able to control their information on the internet. If you think about how ubiquitous search engines are and how much they are part of daily life in terms of people Googling individuals before they meet them, we all know how ubiquitous that is. And certainly this week I heard of the latest example, which was an article in the Scotsman newspaper, which was about restaurants who now Google their customers. Before they actually allow them to have a booking and perhaps their high-class Michelin-star restaurants. So we can see how far perhaps it's permeated into a standard thing to do in modern life. You know, so there are always examples trotted out in terms of this area, in terms of individuals requesting information to be delisted. And it's often about young people making genuine mistakes, often minor issues, minor misdemeanors. It's about people struggling to move on. It's about innocent bystanders or victims who are often caught up in information. The web of information on the internet and how individuals are connected is a complex area, and how information is linked to an individual is an important thing we have to understand. So that's the broader context we've been dealing with. So, as I said at the start, the individuals have the right to be able to complain to the ICO. So that process, the way it should work is, an individual should make a request to Google or Bing or whatever, the search engine first, about their complaint, about what they want Google to actually delist. They should actually explain to Google the links and some arguments about why they actually wish to have those links removed from the search result against their name. If Google actually refuse to respond positively to that request, then an individual can come to the ICO. Normally, if an individual hasn't been to Google, they complain directly to us. We would normally close the case and ask them to actually go through the process of actually making that request to Google first. There's an important process, we think, there, and we've worked with Google and the search engines on this, of making sure that the individuals get the clearest response back as possible from the search engine if the search engine is rejecting their request. We accept this as a difficult and challenging area for the search engine because they are processing thousands of these requests compared to the number of complaints we're dealing with. But it's important that as far as possible the individual understands in a specific context of their request why Google is actually refusing that request. And really as a regulatory process, we're always focused on the data controller trying to get things right time for citizens, for customers, trying to explain it to them. So, how has the ICO been coping with the complaints in this area? In reality, we were concerned at the start about a large volume of complaints hitting us, but actually the filter off in terms of the large number of complaints which have been made to Google, which have actually converted into complaints to the ICO, has been relatively small. So over 40,000 requests have been made to Google in the UK for information to be delisted. That has only actually converted into 472 complaints at our last sort of count of those in August. since the judgment came out. So that's a relatively low conversion rate. So on average, we receive about 34 complaints a month. Why is this conversion rate quite low? I don't think we know. So one response would be, does that mean Google are getting it right? Certainly we can see examples, and some of those examples are listed in the transparency report of Google and other things we hear about. We can see that Google are probably getting the obvious ones right, you know, the ones which most people would accept and would understand in terms of it being a clearly negative impact on an individual, and perhaps an individual isn't in the public domain at all in terms of their profile, etc. And Google are responding to those, and those are probably working well. Is it because some individuals and some data subjects are pushing in borderline cases? They're making the request to Google knock it back, and then they don't wish to progress it to the ICO. It's an area we wish to explore. We don't quite know why those cases aren't coming forward. We're not necessarily inviting them. We're open, we're accessible, we're available. Google will normally point to the existence of the regulator for where individuals can make complaints to. In terms of how the complaints actually work out, over 40% of the 472 complaints we received, 40% of those are actually ineligible, that the individual hasn't been through the proper process with Google, so they need to go back to that point. Sometimes we find it's just businesses complaining about something about their brand name. It's not actually a search against an individual's name, so it's not actually a question of processing personal data. So that happens in 40% of the cases. Another 40%, we agree that Google were correct not to delist the information. And then in 20% of the cases, we actually recommend to Google that they actually do delist the cases. We've developed a range of criteria about how we approach the cases. That's all on the ICO website. So we talk about the individual involved, we look at the link and the search result and the relationship between the two. The last thing I'll talk about very, very briefly is the ICO enforcement notice, which we issued in August of this year. So in that case, it was the first enforcement notice that we issued against Google. Google refused to remove links from stories which had been published about an individual who'd already successfully made a request to Google. So he successfully made a request to Google about a criminal conviction over 10 years ago, a very minor matter. Google agreed to remove those links, but the information essentially was picked up by the media and was essentially republished in a new series of stories. The individual then complained to Google about those news stories based on the removal of the information. Google refused to remove those really on public interest grounds about the public interest in the story, about right to be forgotten, and the individual was caught up in that. We looked at those cases, we felt there were important examples really about how there was actually sort of a disproportionately negative impact on the individual, recognising the importance of freedom of expression and the debate about the stories. But we actually issued an enforcement notice in those cases to actually formally enforce with Google, asking them to delist those particular 9 links. Since issuing that notice, Google have now actually delisted those 9 links in response to our request. I suspect we'll get onto it later. Those links have been removed from all EU domains, but still the question remains open. We're still in dialogue with Google about the extent of delisting from .com and all of those other different services. But I'm out of my 10 minutes, so I'll finish there. Thank you.